Is that your role?
You're live.
Thank you. All right, we are in Senate Judiciary, May 27th, Conference Committee for S.12. And we are just doing a general overview today of where we agree, where we disagree, and hopefully come into some agreements by tomorrow. So Representative Lalone, do you want to start off or?
Actually, why don't you tell us what because we sent over our House proposal amendment. I can tell you what we disagreed with your original Senate version.
So
or you can just tell us what.
So I know the main thing that on the Senate side we're most concerned about is the judicial review piece for accessing, using, and disclosing sealed records. I know that privacy is a very important thing that we're trying to make sure, if we're taking away expungement and many of these records are going to be sealed now, we want to really make sure that they're not going to be misused or used in such a way that will affect people's employment or applications for housing and so on and so forth. A decade or two down the road, as long as they have committed any other crimes. So that's why we created that initial petition piece for access and use. And I think that's also the recurring piece that the two chambers always seem to come back to. There's a couple other areas that I don't think are nearly as substantial as that, but that's the first thing.
Yeah, I think most of our work was done on the exceptions component, the impact or effects of sealings. And we took a lot of testimony on how the documents are accessed, how they are used, the Valcor system, how the state's attorneys deal with documents. We had the archivist in to understand a little more about document retention and the like. So we dug pretty deep, and also hearing from the court, the chief superior judge, and really felt that the petition process for accessing wouldn't be workable. It's just, and we kind of heard that from a number of witnesses. And as we dug into it, we kind of understood and saw how that was the case. And we're also very concerned about the impact on the courts of having a whole bunch of petitions for even accessing documents, and concern over the backlog and such was a serious part of our concern. And so we took that petition out, and we bolstered the exception in subsection C to kind of the introductory.
What page are you on?
I'm looking at the House proposal amendment, and I'm on page 25 of the House proposal amendment. So we, I'm not going to remember exactly what parts of that subsection C that we strengthened, but we put more emphasis on this subsection as the place where one, if they were going to use it in court, sealed document in court, or in a public filing, that they would have to get permission from the court. So we also did a couple other things as far as.
And then what was the standard for whether or not the sealed record can be used in this?
So the standard would essentially, the way it's set up with a party seeking to use a sealed record, pursuant to the exceptions established in the subsection. So the testimony we heard from the chief superior judges, that they would look to see that it is actually one of the exceptions. That would kind of be one of the first inquiries. And then your standard relevance and probative versus prejudicial standard for admitting any kind of evidence. So that's how a court would look at the request to use a sealed document in a public filing or open court. Yeah. So we took out we took out the petition for access as well. It was one of the major other changes, and that also meant that we took out the section where Thank you. That's exactly the excellent circumstance to get that out as well, because
It wouldn't be necessary.
wouldn't be necessary. It wouldn't be necessary, exactly. So. And that was that what I would say is a major change, another important change, but I think at least I understand kind of in advance what some of your concerns were, because you took this up and I understood from the testimony and from the comments around the table when you took an initial look at S12. But that one of the other things that we did was the petitioner having to explain who their documents have gone to, and that's something that came from OPR and I think the Secretary of State's office, that they didn't know if they had documents that were supposed to be sealed. They're not getting notice for expungement, and that was added as well. But I don't think that seems to be an issue. I hope that's not an issue. I haven't heard that it is. And then finally, the other I think bigger change is the deferred sentences, and the testimony we heard. That was probably, in some respects, the most controversial thing that we've looked at in our committee. There was some testimony that this would take away the incentive of the defendant of taking a deferred sentence, but we heard other testimony that isn't the case, and we feel that, we felt that having the document sealed still gives the defendant who has a deferred sentence the incentive to go with the deferred sentence. And the main thing is that we heard in the context of the number of cases that were deferred that involved domestic violence, and that concerned us that those kind of documents were being expunged. So that's kind of where we were on that. So those were the big changes that we made from the Senate version. Did I miss anything?
As much as I also. Yeah, right.
So I think that there's room to figure out the judicial review process and get rid of the petition for access. That's what I understand part of the position, our position to be, but also having some sort of review or a process for the usage and disclosure of the records. And I think you'd sent me something.
Yeah, I can pass this out. So, understanding what some of the concerns were, I worked with Eric, and also looped in just to see that the language was workable. Looped in Judge Zone, the Chief Superior Judge, and also passed it by the Department of State's attorneys as well. So yeah, I'll just go ahead and pass that. And you probably, are you able to email that to Megan?
Should this one come out right now?
No, not right now. That's fine.
Nate has it already, that document?
No. Oh, this wasn't gonna be.
Yeah, I wasn't sure that I was gonna post it. I wasn't sure if we were gonna look at it today, so that's why I didn't. You posted that, but we'll send it. We'll send it to you.
Did you also have?
Oh, yeah, go for it. Yeah. Well, I want to make sure that this is what it posts.
Okay.
He doesn't have this particular one. It's.
Okay, yeah. So I would.
I will post it after the meeting.
All right, so to give you a little background on what this does, and one of the concerns that we were hearing, there's a couple different concerns. There's wanting to have the sealed documents be able to be used by criminal justice agencies for criminal justice purposes, and don't want to tie their hands in their ability to use it for doing an investigation or impeaching somebody in court. And it's my understanding in the bigger picture that it's the trade-off of allowing those kind of uses with us being able to expand the underlying crimes that can be sealed. And that's really where the bargain is. So I'm trying to preserve the ability for criminal justice agencies to use the documents. The concern, and this came out actually more from Marshall's testimony, is for, in their case, when they're using a sealed document in the defense, they may want to use it for, provide to an expert or provide it, in a deposition. And that's the same thing that could happen with a prosecutor. They may want to use a document in a deposition, or expert or an investigation. So somebody else is seeing the doc, that would be a kind of a disclosure beyond just the criminal justice agency or the defense attorney.
So Mark, the defense attorney under your proposal would be able to access sealed records?
Correct.
And would there be, did you hear about any issues regarding attorney-client confidentiality? Because with the requirement, with the requirements that you're talking about, create any sort of issue or a requirement that the defense attorney disclose to anyone else that they're sharing these records. I don't know if I'm phrasing.
So I guess, let me go through kind of how I perceive like the defense. I'll talk a little bit more about criminal justice agency. So defense counsel may have documents that have been sealed. They've gotten an order from court that says they need the documents of this individual. So they have those documents in their possession. And that's kind of where the petition for access didn't make much sense. They have the documents right in the file cabinet. They can't look at them. So let them look at it, figure out how they can be used for defense of a particular individual. Also, they may be receiving through the discovery obligations of the prosecutor. That's one of the separate exceptions. Exception number 7 in the House proposal of amendments.
Yeah.
Eight. That was?
Eight's the one for the defense.
Yeah, no, I'm looking at, so the subject, the discovery obligations, prosecutors have discovery obligations, and that was one we've heard over the past several years, that's one of the big concerns is expunged record they can't turn over, sealed record that he has to turn over. So the defense counsel has documents that are sealed that were turned over or in their possession. That's all fine. They can look at it for trying to defend their case. If they're going to file in court, they have to notify the court and it goes through that process. If they're going to provide it in a deposition, or if they're going to provide it to somebody who's their expert, they don't have to get an order that they don't have to go to court, but they have to give notice that further disclosure of that document would subject the individual to a fine. So that's the defense side. On the prosecutor side, you have the same kind of situation. They've been told that they've gotten an order that certain documents have been sealed, they have them in their possession, and they are investigating and they need to use a sealed document for something. And that's all fine until they use it for a deposition or provide it, show witness. Those are disclosures. And if they're doing that, they have to get an order from the court to allow them to disclose a document in that situation. So
I'm following along pretty well here, Martin, as best I can. So in a situation where the defense, and say the state's attorney's office comes across possession of sealed records, one of those, because the defense is a discovery, if they require it, what obligation does the state's attorney's office now have as far as saying disclosing this information? Notice
they may have to disclose it to the defense. That's an obligation.
but they're asking for it.
Who's asking for it?
It's discovery.
So it's not even necessarily that the other side is asking for it. If it's exculpatory, they have to provide. Brady, is that the case?
Yeah.
So they have to provide that.
Along with the notice or just?
They wouldn't have to provide notice.
They don't have to provide a notice.
Because that's standard discovery. It already happens with sealed documents because there are sealed documents. But if the defense counsel then wants to use it in a deposition, they have to provide that notice.
Okay.
Now, they can use it in their own figuring out how they're going to defend the case.
They have to provide, sorry to interrupt, they have to provide notice or they have to get the petition from the court first?
Just if it's defense counsel, initially I had, when I talked to Judge Zone, it was a petition process and that didn't really work for defense counsel. And that could have, interfere with attorney-client privilege stuff like you were talking about. Defense counsel, as long as they are just using it internally and not disclosing it, they can use it. But if they disclose it, they have to provide notification. Unless they're disclosing it in a public filing or in court, then they have to give notice to the court. That's what they have.
So disclosing it for usage in litigation or disclosing it to their client?
It could be disclosing it, well, the client presumably has access to that or can see that.
If it's the sealed record of an alleged victim, and then you have the client, the defense attorney.
Right.
And the defense attorney wants that sealed record of the victim for, character evidence or whatever. And the defense attorney wants to plan and discuss with his client. That would require a notice to the prosecutor?
No, notice
Okay.
notice to anybody who is not the defense attorney. So yeah, if they're providing the client, it's just a notice. You can't turn this over. You're going
Yeah.
to be subject to $1,000.
Okay. I just wanted to make sure that there isn't an inadvertent policy here that requires notice to the prosecutor about
No.
privacy strategy.
Right.
Okay.
Right, and that's why there's not a petition to the court for them to use in those situations.
Fair enough.
So in the case where the defense attorney wants to have an evaluation done.
Yeah.
Okay, they have to disclose it to the evaluator who's doing, like, say, a mental health evaluation. About this, but no disclosures to the state attorney's office, simply the person that they're providing this information to.
No, they don't have to disclose what they're doing in part of the case.
But they have to notify
If they're
the professional doing the
evaluation,
mental
yeah, the
evaluation,
expert, whatever.
that he or she can use.
Correct,
Okay.
correct.
So,
I mean, yeah, I think the language is fairly straightforward. Hopefully, suggest that page.
and
That's not disclosure to another person,
Yeah,
not to their client. I think that's what was, being disclosed to that evaluator. And they don't tell that person, hey, can't give this to anybody else.
Okay.
That's
so, civil cases, can they be used in civil cases as well, if they're relevant?
I don't see why not. They have the same obligation of getting the court to okay it steps in court.
Yeah,
I mean,
that's,
so
yeah, that was
So-
one thing I wanted to.
No, so if it's just for criminal proceedings. They can't use it unless it's their own document. The exception for defendants using this, like defense counsel.
Yeah.
They can use it for criminal proceedings. It's not for civil proceedings.
Do you have a position on whether or not the defense counsel could use a sealed record in a civil case? Because, I mean, I'm thinking about some of the parallel civil cases that accompany sexual assault claims sometimes, or domestic assaults, TROs, sorts of things.
Right.
And so if a defense attorney is using sealed records to address, for character evidence in the criminal case, should they not also be able to use them in the civil case?
This does not permit that unless it's allowed under the exception under C. And so,
So what about in the case of, someone gets sealed records, they're using it in a criminal case. The case itself moves forward criminally and the defendant is found guilty. Could those records or cases now be used in a civil matter?
about number one.
well, thank you. So an entity or person that possesses a sealed record or an attorney for such entity or person may continue to use the record for any litigation or claim arising out of the same incident or occurrence, including use of the record in reasonable anticipation of litigation. That goes definitely to your concern, what you just raised that. But if it was a completely unrelated
Right.
case, I don't think this provides Okay, for that. But if there's an associated civil case associated with a criminal case,
For example, a criminal domestic assault that arose out of the same incident where they got the TRO that you're talking about. To me, that looks like it arises out of the same incident and you can use it.
Where are you seeing the same incident?
so this, you need to look at the House proposal amendment at page 20, well, no, I guess it's also on this document. It's on number 1 on the first page, sorry. An entity or person,
Oh, in the proposed, okay.
yeah.
Got it. Thank you. Any litigation. Okay, hey, that suffices. Thank you. And then the other piece, the statewide policy, was that,
So here's the issue with the statewide policy. I mean, there may be more than one statewide policy. One thing I'm concerned about is timing of this. And if there's a statewide policy, we're talking probably at least a year, presumably, for that statewide policy to actually be put into place. In the interim, you could get a deluge of requests for expungement, between now and next year. So that's kind of one issue, the policy. I think the other issue is that I think that we are covering the issues by having this requirement that if you use it in court, which we already had came over from the Senate, but we just strengthened that a little bit, I think. If you use it in court in any way, you got to get the court's permission. If you're going to disclose it in any way, beyond the, other than criminal justice agencies, you have to get the court to weigh in on that. So I'm not sure what addition besides some further delay that the policy gives.
I think, with the main concern being accessing records and the prejudice that it could create, I think that having a statewide policy where we're saying, okay, if you have sealed records in your administrative office, here are the rules for your officers and when they can access them, and whatever logs that you need to create as to who accesses and when. And so, yeah, no, I think having some sort of statewide policy would be necessary. And yeah.
So I guess with the statewide policy, I think you're also presumably that each agency would have to adopt the policy as well, right? That's what you're thinking on that. And is this just for law enforcement? Is it just for
Anybody, criminal justice agencies, so law enforcement, SAs, AGs.
I guess I could go for a state policy or not, but my piece was also too, what if an agency doesn't have the policy or adopt the policy? I feel like I was wondering too, like, how does that work?
There can be, similar to the fair and impartial policing, there could be the expectation that you have adopted at least the model policy if you don't develop your own policy.
For such a date or whatever.
Yeah.
I think it's.
Okay.
So maybe we can revisit the policy because we have to go to the floor here in a minute.
right?
I'm good with the proposal that you've made regarding the handout that you just provided. I can discuss it with my members as well, just to confirm, but the other piece I also wanted to mention were the deferreds.
Right.
Our preference would be keeping deferreds as is. I think that if we're making this big of a change, it'll actually make deferred sentences even more enticing for people to enter into. They're a high risk, high reward type of thing. They're also not particularly common, at least in my own brief experience. The only times I've seen deferreds are for really young people or people who were having like their first offense. I'm sure, and I know they've been used for other situations around the state, but just based on what I've seen. So,
All right, so you don't like just limiting it to, listed crimes being sealed, not expunged?
I prefer just getting rid of the changes proposed for deferred sentences and then going to be your idea for the judicial review piece, and then we can come back to the statewide policy.
Yeah, and just one more thing on the statewide policy is. Yeah, I don't, with the protections we're putting around it, I don't want to also tie the hands of investigators or of prosecutors, probably more so prosecutors and how they're trying to use the sealed record to prosecute a case, as long as they're not disclosing it and not using it in open court. And that concerns me for the policy. So,
Well, let's revisit that tomorrow, 'cause we got a minute before the floor, but
What time do you want?
then tomorrow,
You're good.
that, probably,
we're flexible.
or tomorrow is at what? 10, so
We have
10.
10 and.
let's aim for 1:15 tomorrow. And
Sounds
then
good.
we'll go with your idea for the judicial review. Heard sentences, are you good on those?
I don't know.
Okay,
Yeah, I'd like to discuss that a little more anyways. The last I remember from the witness testimony we took, there was one entity who was in favor of keeping the deferred sentence. But it still comes through with recommendations or the approval from the state attorney's office, right? There's still some checks and balances on it as far as who they're gonna send there. What we heard was there, that there was a low number to begin with. Then we need to discuss that a little bit more, but I like your access and use portion of the
Well, we can thank Eric and.
thank you, Eric.
yes, happy to have.
That one part, maybe done.
1 out of 3, yeah.
Well, the hardest part, yeah.
Yeah, it's a good part. Like that.
One, you're back, one for three, you were great.
All right. So.
Get 3 times, come with me.